Okay, so bring along with your rules of court. So I will be starting with the first question. So the first question is, David is a member of an association. The main objective is to promote the multiculturalism in Malaysia. The name of the association is MMCC with an registered address at this particular place. Okay, so here will be the first point because he has addressed the party and the details. Now, the second paragraph is the constitution of MMCC has provided a disciplinary procedure whereby, oh, I haven't shared my screen, sorry. Now, I guess everyone can see my screen, right? Okay, so I will start over again. The first paragraph is David is a member of this association. The objective is provided here that is to promote the multiculturalism in Malaysia, and then the name is an MCC. The registered address is here, so that this is the first hint because they addressed the party and provided their details. Now, the second paragraph is the Constitution of MMCC provides a disciplinary procedure whereby the membership may be terminated by a vote of majority in a general meeting of the association after member has been heard by the disciplinary committee. Now, Ahmad is the current chairman and the registered public officer. Ahmad has a place of business half a kilometer away from the registered office of MMCC, but he resides in Shah Alam, Selangor Darul Ehsan. MMCC has a disciplinary committee chaired by Muniandi, who is one of the members of the executive committee of MMCC. Subsequently, both David and Muniandi had exchanged heated argument over the question of whether MMCC should support a charitable cause initiated by an international organization. In a post on the Facebook page, David publicly criticized the stance taken by MMCC for not supporting that charitable cause. Muniandi, in the capacity as the chairman, issued a letter to David asking him to show cause over the conduct in publicly criticizing the MMCC stance within 14 days from the receipt of letter, failing which the membership shall forthwith be terminated in accordance with the provisions of the MMCC Constitution. David received the show cause letter on this date, 3rd of July this year, but he did not respond to it because he questioned the validity of the show cause letter signed by Muniandi. David is of the view that being involved in the argument, Muniandi is an interested party and ought not to have issued the show cause letter. The letter of the show cause should be issued by the chairman of MMCC instead. On 18th of July, MMCC issued a letter to convene an EGM extraordinary general meeting to pass a resolution that David's membership should be forthwith terminated, and the EGM is scheduled to be held on 19th of August 2024. David now comes for your advice. Answer the following. So by looking at this question, right, I mean, this is quite general because we have seen a lot of details over here. First thing is, who is David? And then where is David's address? Okay, this is the first point. The second thing is the MMCC and the address, and who are the members of MMCC. So we can see the details of each party, unlikely to those other questions that they will hide in details. So that when we see this kind of lengthy question, right, the first thing we have to see what course of action is available to David. Now you see what happened to David. David and Muniandi, the point is here, David and Muniandi exchanged heated argument over the question of whether MMCC should do this and that on the Facebook page. And then he also publicly criticized the stance taken by the MMCC. And then subsequently, Muniandi issued a letter asking him to show cause over his conduct, which is this Muniandi is challenging, not in the sense of challenging, it's asking him to get off already. It's like, because when you do such thing on criticizing for certain party on the social media, which is available to public, it could be a defamation case, as what we can see the DAP recent case, because of one of the politician has criticized, it's not in the sense of criticize, he is just simply pluck everything from the sky and say that who is the relative of who, and then this kind of unsubstantive wordings, so that DAP, the core members or whoever is involved, has filed a defamation suit against that particular politician. I guess everyone have heard that. So this is what happened now, because he has publicly criticized the MMCC job scope on the social media side, so that Muniandi issued a letter to ask him to show cause, because this is the procedure. Whenever in Malaysia, no matter is your work in your working place or other places, you cannot be like simply immediately terminated by a person or a company, because when you file this into the court, right, this will because to be honest, our industrial court is quite pro on the employee, so that the standard procedure is that if you found an employee has committed certain wrongful doing, you must give him certain black and white, ask him to show cause. If he did not explain properly, then you may proceed either PIP, which is there is something like improvement plan, so that you can see whether the person got improved or not. Then if he or she doesn't improve throughout the PIP period, then you can terminate him lawfully. Or if he didn't explain properly in the show cause letter, you may also terminate him, but provided that you can show the conduct of that particular person is quite dangerous to the place. So is everyone understand what is the purpose of a show cause letter? Yeah, because in Malaysia, if you simply terminate someone's employment, it's not like other countries lah. You will see some of the country they will say that, hey, I don't want to see you, I don't like your face already, get off. And then the security will be stand by there and ask you to pack everything. Malaysia, we never do that. We never practice like that. So that everything we must do properly, so that when the employee has filed the action into the industrial court, at least you will secure your position if you have certain things to prove that he or she is quite jeopardizing the company. Otherwise, you will lose the case, and then you have to compensate he or she accordingly. So that now, because you see now the problem is David is challenging the validity of the show cause letter issued by Muniandi, because he's challenging whether or not he has the authority. So you see, the point is here. David received the show cause letter, but he did not respond because he questioned the validity signed by Munyandi. Who is Munyandi? Munyandi, let me see, as a chairman, as a capacity of the chairman of the disciplinary committee only, so that the reason for him to support his case is that chairman of the MMCC should issue the uh, show cause letter instead. So now, what is the course of action available to David? We can extract the details from here onward. So what do you all think? You can reply in the chat group. What do you think about the course of action for David? Okay, I saw one answer here. Wrongful termination apply to a society. Yes, it is. It is. So the question here is surrounding to the unlawful termination of the person, which means that Munyadi has unlawfully terminated David's membership in the society. This is the first point. Now, since the allocation is 6 marks, your answer should contain at least two issues. The first thing is, what would I do is, when we see the allocation is that much, and then you see course of action is available to David. So we got no choice but to explain everything to the marker. So how will I go about on this? My suggestion is you explain to the examiner what is a cause of action. The cause of action, the definition is provided in the case of Lim Kian and Chu Kun, which means that there must be an identifiable plaintiff and the uh, defendant to be identified and to be sued because the plaintiff is identifiable to sue and then the cause of and then the facts of the proceeding will be entitled for the plaintiff to win the case. So that this is how will I structure the answer. Is everyone okay? Now we come to the second question. Who should David sue and name as the defendant? Okay, since it's a 4 mark question, does anyone know who should be sued and named as defendant? Okay, I see one MMCC, but MMCC is not that correct. Yes, public officer of MMCC should be named as the defendant. So this is provided in your Section 9C of your Societies Act 1966, which stated that your public officer should be named as the defendant. So on the fact that Ahmad is the public officer, here is the current chairman and also the registered public officer, so that Ahmad should be named as the defendant in the action. Okay? Okay, now this one I think previously also appeared in past year questions before. What is the appropriate mode of commencement proceedings for the cause of action available to David? 6 marks question. What do you all think? Okay, it's read action. So the read action, the mode of commencement, right? Actually, it's provided in Order 5 and Rule 2 of your Rules of Court. So if you can see from there, the reason of commence the action by way of read action is because there is a substantive dispute to the facts. So based on the facts, right, now he is challenging the validity of whether Muniandi has the authority to issue the show cause letter. Since the fact is surrounding whether he has the authority, this will be the disputed facts in the action. So this will support your answer when you quote read action should be the mode of commencement of the action. Is everyone okay for that? Okay. Now, the fourth question, where should the proceedings be filed? Okay, this one, since it's a 3 marks question, and defamation, we know lah, it's high court already. So when we want to see where should the proceedings to be filed, right? As we already know that Ahmad will be the defendant. So we see, Ahmad has a place of business half a kilometer away from the register office, which is KL. Okay, but he resides in Shah Alam, Selangor. So according to the section 23 sub 1 of the CJA 1964, the criteria for you to bring an action, for you to file the action in the particular high court, there are few criteria, sorry. So the first criteria is, where is the cause of action arose? Second thing, the defendant has a place of business or he resides at the place. And then the third one, last but not least, the facts of the proceedings based at that place. So you see, the cause of action is happened in here, but Ahmad also resides in Shah Alam. So the conclusion is David can file the action in Shah Alam or in KL High Court. Is everyone okay? Pursuant to the section 23 sub 1 of the CJA 1964. Okay, since someone asked me whether or not this is high court, the first thing is your cause of action, defamation, unlawful termination, sorry. Unlawful termination, we assume lah. we assume this is high court action because you either how you magistrate court if magistrate court we just put the SCA you can put either way because the fact is I assume this is a high court action, so I just put CJA first. So if you want to add in as SCA, assumingly this can be happen in subcourts, then you put your subcourts act section 2 of your third schedule. Is that okay? This is my suggestion only because from looking at the facts, you are correct. We don't even know which court is he going to file, but assumingly that he is going to the high court, then we use CJA. But if he goes to the sub court, then we use SCA. Is that okay? Okay, now what is the interim order David may apply from the court to restrain the conduct of the EGM pending disposal of the proceeding that he may file and the procedure involved in applying for the interim order? In your answer, you are to state whether the application can be made ex parte. So by looking at this, I think you are quite clear what is an interim order that is going about on this question, right? So can I have your answer whether or not he is likely to get the sorry, whether or not David is likely to obtain the interim order? Yes. You cannot use an injunction to stop a meeting. But the thing is, you must tell them because 6 marks you have to explain everything from them from the ground. First thing is you must explain what is an injunction based on the wording that the purpose is to restrain the conduct of the EGM pending disposal of the proceeding, so that the injunction itself is served for the purpose that to restrain someone or prohibiting someone to perform a certain act. This is the core purpose of the injunction, so that the injunction no need to explain the categorization of the injunction. But when you talk about the procedure on the fact this is an ex parte, so your your order 29 rule 1 2b has to be included, where the party can apply to the court for an interim order and it lasts for 21 days. And then the contents has to fulfill the contents of the affidavit in support has to comply with Order 29, Rule 12A, which is full and frank disclosure. Okay, so then the service is provided in Order 29, Rule 1, 2BA, which is your time frame is given there like 7 days if I'm not mistaken, and then the court will set down for a hearing within 14 days. Okay, so we already explained the procedures from 1, 2, and 3, because what is an interim order, how to apply, and then how to comply. Then the third one is how do you effect your service? These are the core answer that you have to include in your answer when you answer on the application for everything. But now, your conclusion is that it's provided in Order 29, Rule 1, 2C. An injunction cannot be used to stop a meeting. Okay? you can put this in your conclusion saying that, or on the fact that David's intention to apply the interim injunction is to stop a meeting. Therefore, unlikely that David may use the interim order to stop the meeting as provided in Order 29, Rule 1, bracket 2C of the Rules of Court 20 and 12. Are we okay on this part? Yeah, because the thing is, you see, every time when we see when the question is more than 5 or 6 marks already, sometime you have to form a very concrete answer. It's like you have give them the background and details and the intended action and how can they go on application. Anyhow, you must conclude whether or not he or she can do that. So this is how a 6 marks question have to be answered. But somehow it has an exception like this one, like the question C, because you see the question is only on asking what is the appropriate mode of commencement of proceedings, so that the answer sometimes is very, very short. Is everyone okay on this? Okay, before I start question number 2, right? May I ask, throughout the participants here, how many of you all got F1 in your paper? Okay, I see one. Okay, so for those those who got their F1 in this paper, right? Actually, well done. You all have answered the question on point lah. Just that somehow you know that your answer structure could be an issue, because F1 actually is quite close to pass already. So the reason that you got a minor fail is because of your structure of the answer. So the reason why I have this class is and I spent quite a long time to guide you all on the answering technique is because the allocation of mark serve for a purpose. There is a logic. The reason why they put in those marks is because they want to see how much they can get from you all. So if they put those 3 and 4 marks, just 1 point is enough. But the thing is, if you see the marks allocated is more than 5 or 6 or could be 10, then you know you have to include more and more to make sure that your points are secure and your mark is being secure. But it depends on the case basis lah. All right. So because sometimes people will ask, should my answer be very lengthy? Well, I can answer you, it's not necessary, because some of the answer we can already see. The question itself actually is not that really lengthy, so that you need not to limit yourself into, oh, I must write at least half page or full page in whole. No, just follow the skill. ILAC, issue, law, application, and conclusion. Now, that's why every time I think previously I have mentioned, you must structure your answer by a subheading. So you start off with one heading first. The subheading is concerning on which issue, and then your answer is there. So no matter how messy is your, if even though I mean your subheading does not follow in the sequence, as long as you got the subheadings there, I think the examiner should be giving you a mark because your answer is structured, not writing in the whole essay like oh. And then because sometimes this is quite dangerous, you wouldn't know on which particular point you have missed out. That is the reason why the subheading could be the safeguard of your point. Okay? So, and anyhow, you see, the reason why I go paragraph by paragraph is because in the paragraph, they will give you the details of your answer. You can find your hints there. So if you are in the exam, please prepare few highlights pen. The first thing is you want to highlight the name of the party, then the details of that particular party. So when you read sentence from sentence, you wouldn't get lost. If you read it as a whole, like a helicopter view, then I am very sure lah. From here, people start getting trapped because um because the thing is, you see, oh, this particular paragraph is concerning the defamation. Oh, so very straightforward. The cause of action is defamation. Then bungkus ikat tepi and tapau already. Because you have to read sentence by sentence, then you'll be only find your answer later. Since we have given 15 minutes of reading, at least you do the skeleton first. Then when you are answering, then you just highlight the part and then you identify accordingly. So is everyone okay on this? we must we must use the subheading lah. I mean, the subheading is the best way for you to structure your answer. So due to the time constraint or sometime, I heard some people they're using the point form, but not in every question. Just for the last question, maybe the few sentence, they are using the point form to answer their question, and then they got passed also. So as what I can see is the length of your answer is not really important. As long as the point is there, the mark shall be given by the examiner, and you'll be given the credit because you have answered the question. Okay? Now you see, we come to the second question. Pang obtained a final judgment for a liquidated sum of 150,000 against Devan. In the sessions court, D does not file an appeal and inform Pang that he did not have the means to settle the judgment sum. It has come to Pang's attention that D is entitled to receive a sum of 200,000 from Ganesh, arising from a building renovation contract that D has carried out. Pang is also aware that there's a dispute between D and Ganesh in respect of the payment that Ganesh is seeking a set-off of 100,000 against Devan. So, advise Pang on the procedure he should adopt to recover the judgment sum and the likelihood of recovery of full judgment sum. Any thoughts? I see some of the answer is likely to recover. Mm-hmm. Likely to recover as in recovery of the full final judgment sum. Okay. Okay, we come to here one by one. 150 is P against D. Okay. Now D and G is claiming for D is claiming from G for 200,000. But the thing G is seeking a set of 100,000, which means the 100,000 is likely to be deducted. Okay. And now the problem is the garnishing proceeding. Yes, you are correct. But since it's 8 marks, we still have to explain everything. So the mode of enforcement of judgment, the limitation period, you must also state it in your answer. Because the thing is, they did not provide when the park obtained the final judgment. So that on the fact it did not provide anything, you must tell the examiner that Pang is advised to enforce the judgment within 12 years. And after the 6 years, the leave of court is required to obtain to enforce that judgment. This is provided in your both Limitation Act and also your rules of court. Is that okay? This is your first starting point. So your second point is that the mode of enforcement of judgment. The mode of enforcement of judgment provided in rules of court is judgment debtor summon, writ of seizure and sale, and then the garnishing proceeding, security action, charging orders, and then the last but not least, is the bankruptcy proceedings under the Insolvency Act. But the problem is, since the question is concerning on he does not have the means to settle, and then he knows that D is claiming a certain sum from Ganesh, apparently garnishing proceeding is the most appropriate action that Pang can go further. Is that okay? The reason why I say only Ganeshi is because you see, Devan informed Pang that he did not have the means to settle the judgment sum, which means that even you file a writ of seizure and sale is useless because he is broke until he does not have anything to settle with the judgment sum. He has nothing to offset. He has nothing to sell. So Pang is quite unlucky because the only way for him to go about is on the garnishing proceeding. So you have to once you already concluded garnishing proceeding is the only thing that Pang can go against Devan. You have to explain the garnishing proceeding in the next paragraph, like how to apply and how to serve and then this and that. But there's a but. Problem is here. Anyone can see what is the issue. Why the last sentence is very important. Counterclaim, no. Full judgment sum, partially correct. Hung cannot recover full sum, also partially correct. The thing is, during the previous session, I've mentioned to you all, money in court provided in your Order 49 and Rule 9. Okay? So you cannot attach the money from the court unless you have obtained the order. Okay? So now if you flip to Order 49, Rule 9, it will explain to you very precisely on what is the meaning of money in court. Because the spec is surrounding here, Pang is also aware that there's a dispute between Devan and Ganesh in respect of the payment of 200,000 sum. Some more, Ganesh is seeking a set off of 100,000. So that means you see even today the 100,000 set off is not sustainable. The judgment sum is still within the court. You cannot simply go into the court and enforce the judgment against the court that, oh, okay, I see a question here later. So you see, the question is that we cannot simply go into the court that, or we have to, I want to enforce the judgment. Now you pay me the 200 first, the 200,000 first. You cannot. Even now, you have the final judgment. It doesn't mean that you are the king because there is an ongoing suit, and then we are still not certain whether or not the judgment sum is finalized. So if let's say the money is still in the court, your Order 49 is the core issue that you have to discuss about lah. So since someone has raised out one for Order 49 Rule 9, let me go and check. Let me see, copy the wording first. You see, this is the Order 49 Rule 6. If in a guardianship proceeding, it is brought to the notice to the court that someone, a person other than judgment debtor. No way lah. It's not relevant. It's not relevant. Because now we already can see the judgment debtor. Who is the judgment debtor? And then against that one, that one is the judgment debtor, and he is the judgment creditor. So I don't think so. Order 49 Rule 6 we have to discuss. But the core focus we have to focus is on the Order 49 Rule 9. Is that okay? Okay, once we have finalized with the Order 49 Rule 9, so now we are because we have explained on limitation period to enforce the judgment. And second thing is we have explained how to enforce the judgment. Third thing is we have go about the how does the guardianship proceedings operates. Then the final part is the conclusion. And that since we already put the exception in our third part, which is explaining why order 49 will come out, because now the money is in the court. So the money is in when the money is in the court, and is the procedures under for order 49 rule 9 we have explained. Now we come to the conclusion. Based on this scenario, we have to give more than two options. Okay, since we are not certain on the outcome. So the first option is you can get the full 150 from the court if the set-off raised by Ganesh is not sustainable. This is your first option. The second option is you may entitle he can only entitle to get the 100 to get the 100,000 as the claim after the set-off is succeeded by Ganesh. Third one is this one I am still waiting to check with other people whether or not this can be the last resort. The last resort is if you only claim for the 100,000, then the 50,000, since it meets the threshold of a bankruptcy proceeding. So whether or not Pang can enforce the 50,000 against that one if there is a set-off. This one I'm still waiting for the confirmation and I'm checking. Just wait for I will update in the group shortly or during the next class. I will give you all the answer, because when I see, repeat the answer again. Okay, so the first conclusion is the likelihood. So in assumingly the set-off raised by Ganesh is not succeed, he has no issue, Pang has no issue to claim the entire 150. This is your first outcome. Okay, the second outcome is you can only get 100,000 as the claim, because that one against Ganesh is 200,000, and then Ganesh is seeking 100,000 of set-off, so that if the set-off is succeed, Pang can only attach the 100,000 sum from the court. This is the second option. But the third option is if Pang is stick-faced enough, he still want to get the 50,000 back. This one I have to check whether or not he can enforce the remaining balance of 50,000 by way of bankruptcy action. Because the thing is, I am not sure whether or not enforcement of judgment can do combination in a combination way. It's like, oh, now I'm enforcing a garnishee, but when the garnishee is not succeed, then if there's still a remaining balance sum, I go by way of bankruptcy, because 50,000 meets the threshold of Bankruptcy Act. So this one I'm still waiting for the confirmation, and then I will update to you all as soon as possible. By latest of the next session, I will be able to get the answer. Is that okay? So you see, sometime the question itself is quite short, but you have to discuss based on the marks. The reason why I make it this time, I make it like maybe I talk too much, so that you will think that, oh, the answer have to put very, very lengthy. But when you write, it's quite short only, because I'm explaining in very detail so that you'll be able to know how do you go about the question. So you see the structure is you identify the question, then you put your application and your conclusion. There are 4 parts. First thing is your limitation, then your enforcement of judgment, Because your enforcement judgment, you already explained that garnishee is the appropriate way. So you explain what is a garnishee proceeding and the exception, because now the issue is there. Now the third, and then last but not least, you put your conclusion whether Pang can recover the full judgment sum. So this is how you go for the 8 marks question. Okay, now we come to the second sub question. Peter employed a contractor, Dollar, to undertake extensive renovation work. Without the consent of Peter, Dollar appointed Tan to carry out a part of renovation work. Before renovation work could be completed, the roof of the bungalow collapsed, causing extensive damage. And then Peter filed a civil suit in the High Court against Dollar for damages to the bungalow because of the negligence of Dollar. Servants have served the writ on Dollar, and now Dollar come to you and represent him in court, and he informed that that the cause of roof collapse was attributed to the negligence of Tan. Okay. Advise Dollar on the procedure he should adopt if he wants to have Tan held accountable to him for liability he may face arising from Peter's claim. I think this is quite straightforward, right? For this 7 marks question. So, can I have your thought? Yes, it's a third-party proceeding. Because the reason why I don't want to put him as a core defendant is somehow previously I was also being confused on this kind of question, whether or not the person should be named as a core defendant or a third party. But let me clarify on this. The problem is Peter does not know Tan. Okay? This is the main point. You see, without the knowledge or consent of Peter, Dollar appointed Tan. So apparently that Peter does not know Tan. So the only thing is you go for a third party proceeding is more appropriate. But in other way, if Peter knows who is Tan, but he forgotten or out of an overlook, he has forgotten to include Tan as the party, so that you can only add Tan as the core defendant. Is everyone clear on how to differentiate between a third-party proceeding and adding a core defendant? Okay, so as we already know that this question is concerning on the third-party proceeding. Okay, so the third-party proceeding you have to discuss all about is on the question on the order 16 and 1. So you have to introduce what is a third-party proceeding, or because you have to explain to the examiner that Tan is a joint tortfeasor. The word joint tortfeasor is that Tan also contributed certain tortious action in this particular case. So this is the reason why we call him as a joint tortfeasor. So it is provided that in order 16 and rule 1, you can bring a third party in the action if he or she is one of the joint tortfeasor. Okay, so under your order 16 and rule 1, you have explained, you have justified why you bring this action by way of third party proceeding. Explain again on the part. Saroja, may I know which part you would like me to explain again? You mean on the clarification on how to differentiate between adding a co-defendant and third-party proceeding, right? Okay. So sometime you'll be confused. You see the wording here. Without consent or knowledge of Peter. So that means Peter does not know the existence of Tan. He does not know at all. So the only reason to make him know is by way of third-party proceeding. However, on another side, if Peter know who is Tan, but he forgotten to include Tan as the co-defendant, then it's up to his option or Dola's option to add Tan as a co-defendant. Is that okay? All right, so we proceed further. So just now I stopped at the explanation on Order 16 and Rule 1. Why you want to bring a third-party action, and the justification is that Tan is a joint tortfeasor. Okay, so the second part is on the procedure. So the procedure is that you have to follow whatever provided in your Order 16. So the Order 16 has given, let me check again on the Order 16 first. Your procedure. Okay. So the procedure somehow, you have to see whether or not it requires a leave of court on the fact that uh on the fact that Dollar has not served any defense, so that he can apply to the court to issue a third party notice without the leave. Is that okay? Because the thing is, if he has to enter appearance, of course, he has to enter appearance one. But the question is, whether or not he has to serve, he have to get the leave. The question is here. The reason why I put a very lengthy uh time on here is because I want to let you all know on which situation you have to get the leave of court, so that if now Dollar has served his defense, then he has to obtain a leave of court to issue a third party notice, and then you have to explain more. But now he entered appearance, but he has not served the defense. Yes, then he can issue a third party notice without the leave of court. Is that okay? It is provided in your Order 16 Rule 1 and Sub 2. You can see the wording there. If you already served your defense, then the issuance of the third party notice is required to along with the leave of court. Now we come to the next part. We already explained we are in the procedure already. Then once the third party notice has served to the has served to Tan, then the court will fix a date for the third party direction. This is provided in your Order 16 and Rule 4. Okay? The third party direction is that the court will determine the issue accordingly under Order 16 and Rule 4. So you see the 7 marks question now. This is how you structure. The first thing is you explain why there is a third party proceeding, or because in Order 16 and Rule 1, it says you can bring a third party proceeding is available for any joint tortfeasor. Yeah, this is provided in your Order 16 Rule 1 and Sub 1 Sub A against a person who is not ready to a party to the action for any contribution or indemnity. This is so-called the joint tortfeasor. Now, the next issue is whether leave is required to serve to issue a third party notice against Tan on the fact that the writ is only served to him. So which means that he hasn't served the defense. Okay, so now provided so that the leave of court is not required, we settle on the second part. Issue of third party notice without the leave of court. Third part is the procedure, because you have to tell them on how to serve and for Tan to enter into appearance. Then the third party direction, Order 16 Rule 4. Is that okay? Okay. Now we will come to the third question. Pawan sold engineering spare parts to Daniel valued at this sum, and then Daniel issued 3 post-dated checks to Pawan. 2 checks cleared, while third check was dishonored. Upon presentation, Pawan filed an action in 2024 March in magistrate court against Daniel based on the dishonored check. After action was filed and Daniel filed his defense, Daniel appealed to the Pawan to delay the proceeding for 2 months as he wanted to settle the claim out of court. More than 3 months have lapsed since Daniel filed the defense in court, and Pawan now wants to continue with the action in court and obtain a speedy judgment against Daniel as he has failed to settle the claim. Okay, I'll advise the procedure he should adopt a speedy judgment. How? Okay, I can see Order 14. Order 14. The writ action is already filed. Okay, so you see, well, the 10 marks question is separated into 3 parts. Never mind. The procedure, Order 14 and Rule 1. Okay, so the first thing is you have to, this is the general part, like how to obtain the speedy judgment is that you file and you apply to the court satisfying the following requirements. In Pawan's belief that Daniel has no defense or counterclaim, and then the the procedures has been complied, which is the statement of claim has been served to Daniel. Okay, and then he has entered into defense. Here ma. So this is how are you going to answer for the first part? Because this is on the procedure to adopt a speedy judgment. Okay? But last but not least, put some application thing inside lah, because how to apply ma? Your apply is by way of notice of application supported by affidavit as provided in your order 14 and rule 2, because the application is part of the procedure. Is that okay? Okay, now we come to the possible im impediments to obtain a speedy judgment and whether Pawan can overcome them. Okay, what do you all think? It's not on whether order 22B offer to settle does not apply here. Oh, no. 4-1 is the leave to defense, that one. The 4-1 is that when the defendant wants to defend for such as set off and counterclaim, this is like you have a ground to defend to the summary judgment, and this is going to challenge for the summary judgment, but apparently he has no good ground to defend. So I don't think so. The show cause is applicable. But the problem is the timeline. The application is you enter the defense, then you must apply. So as you can see, from order 14, rule 1 sub 1. Let me highlight. you see, the point is here. Defendant has entered an appearance in the action. Plaintiff may bring, which means that he should apply for summary judgment at the time he has entered into the defense. But you see, the problem is more than 3 months. Do you think that this is a challenge? So this could be the possible challenge that Bar 1 may face. So the problem is, we have to quote this because the application is at the time when Daniel has already entered into appearance, and then he has filed the action 3 months after the Daniel has entered into appearance. But how should he overcome the issue? This is explained in the case of, let me type. This is the case. In this case, the court held that the delay can be overcome if your reasons is good. So Part 1 can rely on this case by explaining the reason why there is a delay for the application in the summary judgment. So he can overcome. Because you see, this is why Daniel made him, this is why the application is delayed, because Daniel want to settle out of court for 2 months, but you see, after 2 months the thing also cannot settle, then we go by way of Order 14 without any choice. Is that okay? Okay, the likelihood of obtaining a speedy judgment. Any thoughts? Since this is a 3 marks question, and then we already explained it in Order 14 Rule 1, what is the thing has to comply with the Order 14 Rule 2, or he has no defense. Okay, settle. And then I don't think so he has any defense because you ask people to settle out of court, turns out you did not settle, what is the defense? Okay, so is there any question for this? If no, then I will proceed to the explain for number 2 again. Okay. Number 2 essentially is asking the possible challenges that Part 1 may face. Okay, so you may see again the wording in Order 14 and Rule 1. In the action to which this rule applies to a statement of claim served on the defendant, and then defendant has entered in appearance in the action. Plaintiff may, on the ground that defendant has no defense to claim, including the writ, then apply to the court for judgment against. So the essential wording, the essential of the Order 14 Rule 1 is that the plaintiff has to apply to the court promptly, the timeline. So the question is here, what is the possible challenge? Because you see, more than 3 months time, more than 3 months time has lapsed, then Pawan wants to continue with the action and obtain the summary judgment. So you see, there's a huge gap. 3 months. After the 3 months, he wants to apply for summary judgment. This is the possible challenge. Did I answer to your question? Okay. So when you see sometime there are few challenges that the plaintiff might face. First thing is whether the timeline to apply for summary judgment is within the time frame. Second thing, whether or not the defendant has a triable issue or any defense. Third thing is whether your order 14, the entire thing is complied. So when you see the possible challenges, usually it's based on the procedural. So the procedural we already seen one previously is on or actually he does not comply to the affidavit or he does not comply within the time frame. This is now question. This is a question of now. But sometimes they will be asking you, oh, now what if the defendant have a triable issue? These are the possible challenges lah. Is that okay? On part three, the likelihood of obtaining a speedy judgment is just a conclusion of Roman number one. Because the Roman number one, you already explained why he has to go by way of summary judgment. Because the summary judgment is that when you put in because in your Roman one, you already written what are the procedural rules and the thing has to be complied. First thing is the procedure. When defendant has been served on the writ and statement of claim, and then now he entered into defense. Okay, so this is the first part. Then how do you apply or your affidavit and the notice of application? The contents of the affidavit have to include that in the plaintiff belief, defendant has no defense. So to answer Roman number 3, right? I don't see Daniel has any defense now because he says he wants to settle out of court, but after 2 months' time, it still cannot be settled. So unlikely that Daniel has a defense. Is that okay? Okay. Now we come to the third question. A plaintiff commences a writ action against defendant. After entering appearance, defendant filed and served a defense of counterclaim. Plaintiff filed and served a reply defense to the counterclaim. Defendant has taken objection to the plaintiff defense to the counterclaim on the following ground. Okay, I like this kind of question because I can answer accordingly based on the subheading here lah. Defense counterclaim consists bare denials to the counterclaim. Second issue is unsubstantiated and scandalous allegation in the defense. Several paragraphs consist of legal submission, advise the defendant on the procedure he should adopt in respect of the defense to the counterclaim. Any thoughts? Okay, let me see. Defense must be substantial denial, all right? Why order 19? Order 19 is default on defense wall. I don't see. Okay, the default of defense the default of defense simply means that you have entered into appearance, but as a defendant, when you fail to serve the statement of defense to the plaintiff within the time frame stipulated, then you will be only caught under order 19, which is the default of defense. So I think someone has answered it correctly, because yeah, these are the issues pertaining to the question. So when you see this kind of question now, it's a bonus, because the thing is, they have separated out the issues accordingly. The first issue is on the bare denials. What is the meaning of a bare denial? Is simply like a kid telling you, I don't want to admit. But without, he just tell you that he is denying, but without any justification or grounds. This is the so-called bare denials. So if you look at your question, if you look at your order 18 and rule 13, if you want to deny, you must rebut specifically along with the grounds, so that based on the fact the bare denials does not suffice the rebuttal. So this is the first part. And then the second part is on the unsubstantiated and scandalous allegation. This is very likely that the pleading can be struck out by the court under Order 18 and Rule 19, striking out pleadings because of scandalous, vexatious, frivolous claim, and then no reasonable of cause of action or abuse the process of court. The plaintiff may apply to the party may apply to the court to strike out the pleadings under or by way of notice of application supported by affidavit, which is an interlocutory application under Order 32(1). Is that okay? The first and second part we already sort out. Then the third part is the paragraph in the defense consists of legal submission. This is for this you have to go back on your Order 18 and Rule 7 again. Rules of pleading. You must plead the facts. Plead the facts, not evidence. Plead the material facts, and plead the facts, not law. Although you can overcome in your Order 18 Rule 11 that point of law may be included. This is explained in the case of here. I will put here. But raising a point of law is totally different from the legal submission, because the legal submission is that, oh, you are citing every single case to make it as if a legal submission, because you want to support your case. But point of law is that, oh, now I'm telling the court that, oh, the party has negligently, recklessly, or whatever thing, legal terms only. Legal terms may be consist in your pleading. Is that okay? All right. So since there are subheadings to each of the issue, so I guess the answer you just answer according to the subheadings will be suffice. That is the reason why I say subheading is quite important now. Okay, now we come to the second part. SWB operates a storage business, and the customer may store their assets in the warehouse. John and Sally operated a restaurant, ceased their business, and they decided to store the furniture, fittings, and equipment from the restaurant in a warehouse operated by SWB for an annual storage fee of for 10,000. John and Say subsequently had differences between themselves and could not resolve. John, without the knowledge of Sally, asked SWB to release the item so that he could start a new business without Sally. When Sally discovered this, she also approached SWB and demanded the item to be released. Both John and Sally have retained the service of their own respective lawyer, issue a demand letter to SWB, demanding the item to them respectively. Advise SWB on the procedure he should adopt to resolve the challenge. What do you all think? All right. Correct. It's interpleader. Then you tell, since the fact is concerning on the 8 marks question, you must tell the examiner, interpleader is differentiated into two categories. One is stakeholder interpleader. Another one is sheriff interpleader, based on the fact that SWB is holding the property between John and Sally, so that stakeholder interpleader is more appropriate. This is your general introduction. So when it comes to the second part, it's on the procedure. So the procedure is provided in Order 17 and Rule 3. And then by way of filing of OS supported with your affidavit. So in your affidavit, you have to comply with the rules that SWB has no interest in the property, and then does not collude with any claimants, and then he is willing to transfer or pay the property into the court. Then you have to comply with the service. Service is provided in Order 17 Rule 4, which is at least 7 days before the return date, and then the court will fix a day for hearing and determine the issue under Order 17 and Rule 5. Is that okay? Because the first part, we already give the introduction that interpleader is the appropriate action, but which kind of interpleader is more appropriate? So now when we already found out that stakeholder interpleader, then we come to the next part on how to apply and the procedures. The procedures is that, or your OS plus your affidavit. Then your service then the court fixes a hearing. So you see, the sequence is here. Every time when you put your introduction there, when you introduce the fact already, then you put on the procedure. The procedure is how to apply, how to service, and then the court will fix a date for hearing. This is how you answer the question. Is that okay? You will see me, if you notice, this is how I answer the question. Every time I will see, you introduce the fact first, then you go on for the procedure. The procedure is only consists three parts: how to apply, and how to service, and then the court will fix a date for hearing. These are the sequence. Because the thing is, you must tell your client what are you doing. You must tell the examiner why you do that, and how do you do that complete uh without any mistake. You must explain. This is how you explain and how you present your answer. First thing is you have introduced the general. You have give them your answer on which particular order and the rule. Then your procedure, you must tell them, oh, if I want to go about on this order, then the next part is this and this and this. So your answer wouldn't run far away because you already tell them how to apply. Then after your application, you must explain to them on how do you effect the service. Once it has been served, then the court only can fix a date. These are the sequences. Okay? Now, part C. The plaintiff filed a writ against defendant for breach of contract after the service and writ after the writ and SOC served to the defendant, and then the defense has been filed. Now, the plaintiff wants to amend the writ and statement of claim to this and this. First thing, include defendant's wife as a core defendant, as he is a crucial witness, and include a defamation as a cause of action as in the statement of claim. And the wife allegedly made a defamatory remarks against the plaintiff after the writ has been served on the defendant. Now, the first part is advise the plaintiff on the procedure he should adopt to amend the writ of starment and the statement of claim. Any thoughts? I think most of you has been caught by the question itself. Even for me, when I look into the question, this is what am I answer in the first place. Okay, never mind. The first part is on how to amend. How to amend, not the likelihood. You see, how to amendment of writ and amendment of statement of claim are found under different rules under Order 20. So in the state amendment of writ, you can find in Order 20 and Rule 1. Can you go and flip it? amendment of writ as per Order 20 and Rule 1 is that the plaintiff may, without the leave of court, amend the writ at any time before the pleadings are closed. So now, what is the meaning of close of pleadings? Which means that now we know the sequence of pleadings are your statement of claim, your statement of defense, then your reply in the statement of defense, and then reply to that, and then your rejoinder lah. Okay, so when the court say now pleadings are closed, I want to fix for trial already. So this is a so-called close of pleadings. So this question is asking you how to amend on the fact that the writ and the statement of claim are served to the defendant. The question here is asking you how to amend. Okay, how to amend it's not same as whether he can amend. So the question here is the procedure on the amendment of writ and the statement of claim. So if you see Order 20 and Rule 1 says that you can amend the writ without the leave of court before the close of pleadings. This is one of your answer. Then the second question is how to amend the statement of claim. The statement of claim is provided in your Order 20 and Rule 3. You can amend the pleadings without the leave of court before the close of pleadings. So that here are the answers to this question. Is that okay? Because the issue is, what can he do to amend? The defense has been filed does not mean that the court has. Because because the thing is, now, you see, the sequence of pleadings actually is quite, the pleadings are categorized into, there's a sequence of pleadings. Even you file the defense, I still can reply to the defense. It does not mean that after your statement of defense is a close of pleadings, unless the court be directed. You still can file subsequent defense, subsequent pleadings. Because in the civil court, because in the civil case, right, we are not only confined to statement of claim and statement of defense. You can still reply, as you can see from the previous questions, right? You reply, and then you see after the reply, they still can reply also until the court directed that okay, now the pleadings is closed. Then this is the question. So since the pleadings is not closed, you can amend anytime without the leave of court. Is that okay? Now the second part, now is the fruitful session. Because advise plaintiff if the court will likely allow his application to amend the writ and the statement of claim. Now you can only answer these two questions. So you see, he separated the answer into two sub-questions. So we look at the first one, one by one. Adding a co-defendant. The plaintiff want to amend the writ and statement of claim to include the wife as include the defendant's wife as a co-defendant, whether or not it's allowed. Anyone? I don't think so. The cause of action should be the main answer lah. But the thing is, you are adding a party. If you look at your Yamaha motor case, and also the if you look at the case of Yamaha motor, there are few criteria, there are few requirements. First thing is, uh, the party, one of the requirement is the parties of the suit will not be changed. So it against the rule in the case of Yamaha motor. Because in Yamaha motor, there are few criteria. Bona fide application, it does not change the parties in the action. But the fact here is you are changing the parties in the suit. So unlikely that you can do that. So if you really want to add a party, right, you should go by way of order 15 by adding that so. And some more, if you simply add the defendant's wife as the co-defendant, you're also against the rule. You're also against the principle in Yamaha Motor already. You prejudice the other party. So the only way to resolve it is by way of order 15. You want to add a party, right? Order 15, rule 6. Is that okay? Now, the second issue is include defamation as a cause of action in the statement of claim, as the defendant and his wife has allegedly made the defamatory remarks against the plaintiff. Okay, now here comes to the order 20 and rule 5, sub 5, whether or not it is allowed. Actually, it's not allowed. Yes, you are right. This is a new cause of action. Because the wording there, the wording in Order 20 Rule 5 sub 5 says that you can add or remove a cause of action, or not remove in the sense of substituting the cause of action arising out from the same fact. Based on the issue there, this happened after the writ and statement of claims, served on the defendant. So it against Order 20 and Rule 5, it's not allowed. So your conclusion is both amendments also not allowed. Is that okay? Okay, so what time is it? Oh, 23. Since our class is until 11:30. And then I think number four onwards are quite lengthy. So I will stop a recording here. I will stop my recording here lah.